Erev Tov Rabotai, we are continuing with our Mishna Yomi, Masechet Sanhedrin. We are up to Perek Gimel, Mishnah Dalid. Today's Mishnayot should be Le'elu Nishmat, Neria ben Svetlana, Ranbai, Eliyahu ben Burchai Israelov, Chana bat Miriam, Sason ben Ryan, Yoshua ben Shifra, Menuchatam began Eden, Amen. Le'avdi ben Chaim lechaim, v'derefua shelemav, Daniel Shalom ben Rosa, Betor Shah Chole Yisrael, and Achlama Merav Binyamin, Od Zion Chai ben Dvorah. A person is disqualified to judge or testify about a close relative. The Mishnah lists relatives that are included in this restriction. Now, a person cannot judge or testify about his relative either in favor of him or against him. And two relatives cannot serve as judges on the same court or testify together. These rules apply to both capital cases and monetary cases. The Mishnah begins, Ve'elu en akrovin. These are the relatives that a person cannot judge or testify about. Aviv, ve'achiv, ve'achei aviv, ve'achi imo. His father, his brother, his father's brother, his mother's brother. The Torah in Dvarim, chapter 24, verse 16 states, fathers shall not be put to death because of their sons, nor shall sons be put to death because of their fathers. The Gemara in Sanhedrin, page 27b and 28a, explains this to mean that a father may not be put to death based on the testimony or judgment of his son, and vice versa. And the Gemara explains further that since the verse uses the plural form fathers, it refers to two fathers who are brothers. The verse therefore teaches that a father is disqualified from testifying not only about his own son, but also about his brother's son, his nephew. Likewise, a son is disqualified from testifying not only about his father, but also about his father's brother, his uncle. It logically follows that since a father cannot testify about his brother's son, he certainly cannot testify about the brother himself. Furthermore, by stating sons in the plural tense, the verse teaches that these two sons who are first cousins may not testify about each other, so it comes out from the verse that a person cannot testify about his father, son, brother, uncle, nephew, or cousin. The Gemara also learns from the verse that a person cannot judge or testify about his mother or her relatives, such as her son from another marriage, like his half-brother, her brother, his uncle, and her brother's son, his cousin. Now, although the Mishnah mentions only male relatives, the same applies to their female equivalents. Therefore, a man cannot judge or testify about his mother, daughter, sister, or half-sister, aunt, niece, or female cousin. Now, in most of the Mishnah's cases, the disqualification goes both ways. For example, although the Mishnah says only that a son cannot testify about his father, the opposite is also true. A father cannot testify about his son. However, this two-way disqualification does not apply to every relationship, like we will see B'ezrat Hashem b'li neder later in the Mishnah. The Mishnah continues, Ubal achoto, ubal achot aviv, ubal achot imo, ubal imo. The husband of his sister, the husband of his father's sister, the husband of his mother's sister, the husband of his mother who is not his natural father. Now, like we learned, a man cannot testify about his female relatives, such as his mother, his sister, or his aunt. In many areas of law, a husband and wife have the same legal standing. A husband is regarded the same as his wife, and a wife is regarded the same as her husband. Therefore, if a man is disqualified to judge or testify about a relative, he cannot testify about that relative's spouse either. Therefore, for example, just as he cannot testify about his sister, he cannot testify about his sister's husband. So for this reason, the Mishnah states that he is unfit to testify about the husband of his sister, the husband of his aunt, mother's sister, or father's sister, and the husband of his mother. V'achamiv v'giso, his father-in-law and his brother-in-law, meaning the husband of his wife's sister. Now, since the husband is regarded the same as his wife and vice versa, her relatives are like his relatives. Therefore, a man cannot testify about his wife's father, his father-in-law, because her father is like his father. And for the same reason, he cannot testify about his wife's brother or his wife's sister. The Mishnah takes it one step further and teaches that he cannot testify even about the husband of his wife's sister, since that husband is like his wife's sister, and his wife's sister is like his own sister. His wife's child from another marriage is also a relative who cannot testify, as the Mishnah will state explicitly. Also included are her nephews and nieces. Hen uvnehen v'chatnehen. The people listed in the Mishnah, their sons and their son-in-laws are all included in the restriction. Now we learn from the Torah that a man is disqualified to judge or testify about his nephews and cousins by adding their sons. The Mishnah includes the son of his brother and the son of his sister's husband, or his nephews. It also includes the son of his father's brother and the son of his mother's brother, who are his cousins. When the Mishnah says their sons-in-law, it adds the husband of his nieces, such as the son-in-law of his brother, and the husbands of his female cousins, such as the son-in-law of his father's brother. Since one cannot testify about his nephews or male cousins, he also cannot testify about their female equivalents, namely his nieces and female cousins. And since he cannot testify about his nieces and female cousins, he cannot testify about their husbands either. In addition, the Mishnah includes here his wife's brother, son of his father-in-law, and his wife's nephew, son of his brother-in-law. Now the Mishnah, the commentators explain that some relatives are included because of the rule that a husband and wife are treated alike. However, the son or son-in-law of a relative by marriage is forbidden only if he is also the son of the blood relative. For example, the son of a sister's husband is forbidden if he is also the son of the sister, but not if he is the son of the sister's husband from another wife. V'cholgo levado, his stepson, the son of his wife, alone is included, but not his stepson's son or son-in-law. A man's stepson, the son of his wife from another marriage, is included in the restriction because the son of a man's wife is like his own son in view of the rule that a man and wife are alike. And furthermore, even if the wife of a stepson even the wife of a stepson is included since she is like her husband, the stepson. However, the son or son-in-law of a stepson is not included. As a rule, the range of forbidden relatives extends only one generation up, uncles, and one generation down, nephews. It does not extend across two generations, great uncles, great nephews. One may therefore testify about the son of his stepson, his wife's grandson, since he is two generations removed. A grandfather is nevertheless disqualified to testify about his own grandson. Now, the Mishnah mentions most but not all of the forbidden relatives. Among others, a man's grandchildren and his wife's cousins are left out. And the Arts Elucidated brings a chart for all the relatives specified in the Mishnah, as well as their sons. Now, before citing the end of the statement, the Mishnah interrupts it to teach the Tanaim of an earlier generation disagreed. Amar Rabbi Yossi said, Zu Mishnah Rabbi Akiva. This Mishnah, the previous statement, follows the view of Rabbi Akiva. Aval Mishnah Rishonah, but an earlier Mishnah taught, Dodo ben Dodo, only relatives such as his uncle, the blood brother of his father or mother, and his uncle's son are included in the restriction. According to this earlier ruling, the restriction applies only to blood relatives and not to those who are related merely through marriage. And the Rav tells us that en halacha ki Mishnah Rishonah, the halacha does not follow the opinion of the Mishnah Rishonah. The halacha follows the opinion of Rabbi Akiva. The Mishnah now cites the end of the first Tana statement, V'chol ha'ra'ui liyarsho, but only one who is fit to inherit a person after his death is disqualified from judging or testifying about him. Those who will not inherit him can judge or testify about him. The laws of inheritance define which relatives are disqualified to judge and testify. When a man dies, his property goes to his sons. If he has no sons, it goes to his daughters. If he has no sons or daughters, it goes to his father. And if his father is not alive, it goes to the nearest relatives of his father, starting with his father's other children and then his father's brothers. However, it does not go to his mother and certainly not to relatives of his mother, because a person's estate must remain in his father's family. The Mishnah states here that anyone who stands to inherit a person's property is disqualified from testifying about that person. This implies that any relative who does not inherit a person can testify about him. Accordingly, since the relatives of his mother do not inherit him, they are eligible to testify about him. Now, when the Mishnah listed relatives of his mother's brother, his mother's husband, etc., it did not mean to imply that they are disqualified to testify about him. In fact, they can testify about him since they do not inherit him. Rather, the Mishnah means only that he is disqualified to testify about them. Not only are a man's mother and her relatives ineligible to inherit him, but so is his wife and her relatives. Nevertheless, although the relatives of a man's wife, his father-in-law, his stepson, etc., do not inherit him, they are disqualified to judge or testify about him, since spouses are treated as though they were the same person. The relatives of his wife are like his relatives, and therefore they cannot testify about him, even though they do not inherit him. The Mishnah cites another law about the disqualification of relatives. And if anyone was a relative at the time of the event, he is disqualified from testifying about that event. He is also disqualified if he is related at the time of giving testimony, even if he was not related at the time of the event. However, if someone was a relative to marriage and before the event took place, he stopped being a relative, for example, because his wife died, he is eligible to testify about the event. For example, if a certain man was involved in an event and the event was witnessed by his daughter's husband, then if the daughter had died before the event took place, her husband can testify about it because he was no longer related to her father at that time. Rabbi Yehuda says, "Afilu meta bito v'yesh lo banim mimena harei ze karov." Even though his daughter died before the event took place, if her husband has children from her, he is still his father-in-law's relative and is therefore disqualified from testifying about the event. According to Rabbi Yehuda, although he stopped being a son-in-law when his wife died, he is still related to her father, to his children, for they are her father's grandchildren. And the Rav tells us, V'nachak Rabbi Yehuda, that Echad does not follow the opinion of Rabbi Yehuda. And that is then of Mishnah Daled. Mishnah names other people who are ineligible to judge or testify. Alayev, Soneh, the friend and the enemy of a litigant, cannot judge or testify about him because they are biased. Now these terms are defined. Ohev zeh shushbino, his friend is his groomsman, meaning a good friend of his who took care of his wedding banquet and sent him wedding gifts. Now this friend cannot judge or testify about the groom during the 7 days that begin with the day of the wedding. Soneh kol shelo diber imo shosha yamim be'eva, his enemy is anyone with whom he did not speak for 3 days out of hatred. Now the sages disagree with the previous Tan in regard to giving testimony. Amrulo, they said to him, Lo nechshedu Yisrael al kach. The Jewish people are not suspected of this, meaning they would not give false testimony out of love or hatred. Therefore, even a litigant's friend or enemy can testify about him. The sages allow a friend or enemy only to serve as a witness. They agree that he is unfit to be a judge. Since the witness merely reports what he saw or heard, even a friend or enemy can be trusted to testify accurately. A judge, though, must weigh the two sides of the case and reach a decision based on his understanding and reasoning. Even if he wants to find the truth, a friend will tend to miss arguments that go against the litigant, and an enemy will tend to miss arguments that go in the litigant's favor. And the Rab tells us that Halakha does follow the opinion of the Rabbanan. And that is the Rabotai of today's Mishna Yomi. Baruch Adonai Leolam. Amen v'amen.